Freedom of speech. For the freedom of speech in specific jurisdictions, see freedom of speech by country. Um, Freedom of speech is the political right to communicate one's opinions and ideas using one's body and property to anyone who is willing to receive them. The term freedom of expression is sometimes used synonymously, but includes any act of seeking, receiving, and imparting information or ideas, regardless of the medium used. In practice, the right to freedom of speech is not absolute in any country, and the right is commonly subject to limitations, as with libel, slander, obscenity, sedition, including, for example, inciting ethnic hatred, copyright violation, revelation of information that is classified or otherwise. The right to freedom of expression is recognized as a human right under Article 19 of the Universal Declaration of Human Rights and recognized in international human rights law in the International Covenant on Civil and Political Rights. Article 19 of the ICCPR states that everyone shall have the right to hold opinions without interference, and everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through any other media of his choice. Article 19 goes on to say that exercise of these rights carries special duties and responsibilities, and may therefore be subject to certain restrictions when necessary. For respect of the rights or reputation of others, or the protection of national security or a public order public, or of public health or morals. Freedom of speech may be legally curtailed in some religious legal systems and in secular jurisdictions where it is found to cause religious offense, such as the British Racial and Religious Hatred Act 2006. The right to freedom of speech and expression. Concepts of freedom of speech can be found in early human rights documents. England's Bill of Rights, 1689, granted freedom of speech in Parliament, and the Declaration of the Rights of Man and of the Citizen, adopted during the French Revolution in 1789, specifically affirmed freedom of speech as an inalienable right. The Declaration provides for freedom of expression in Article 11, which states that the free communications of ideas and opinions is one of the most precious of the rights of man. Every citizen may accordingly speak, write, and print with freedom, but shall be responsible for such abuses of this freedom as shall be defined by law. Article 19 of the Universal Declaration of Human Rights, adopted in 1948, states that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Today, freedom of speech or the freedom of expression is recognized in international and regional human rights law. The right is enshrined in Article 19 of the International Covenant on Civil and Political Rights, Article 10 of the European Convention on Human Rights, Article 13 of the American Convention of Human Rights, and Article 9 of the African Charter on Human and People's Rights. Based on John Milton's argument, freedom of speech is understood as a multifaceted right that includes not only the right to express or disseminate information and ideas, but three further distinct aspects. First, um, the right to seek information and ideas. Second, the right to receive information and ideas. Third, the right to impart information and ideas. International, regional, and national standards also recognize that freedom of speech as the freedom of expression includes any medium, be it orally, in written, in print, through the internet, or through art forms. This means that the protection of freedom of speech as a right includes not only the content but also the means of expression. Relationship to other rights. The right to freedom of speech and expression is closely related to other rights and may be limited when conflicting with other rights. See limitations on freedom of speech. The right to freedom of expression is also related to the right to a fair trial and court proceeding, which may limit access to the search for information or determine the opportunity and means in which freedom of expression is manifested within court proceedings. As a general principle, freedom of expression may not limit the right to privacy, as well as the honor and reputation of others. However, greater latitude is given when criticism of public figures is involved. The right to freedom of expression is particularly important for media, which plays a special role as the bearer of the general right to freedom of expression for all. However, freedom of the press is not necessarily enabling freedom of speech. Judith Lichtenberg has outlined conditions in which freedom of the press may constrain freedom of speech. For example, where the media suppresses information or stifles the diversity of voices inherent in freedom of speech. Lichtenberg argues that freedom of the press is simply a form of property rights summed up by the uh, principle no money, no voice. Origins. Freedom of speech and expression has a long history that predates modern international human rights instruments. It is thought that ancient Athens' democratic ideology of free speech may have emerged in the late 6th or early 5th century BC. Two of the most cherished values of the Roman Republic were freedom of religion and freedom of speech. Freedom of speech, dissent, and truth. Before the invention of the printing press, writing once created could only be physically multiplied by the highly laborious and error-prone process of manual copying out. No elaborate system of censorship and control over scribes existed, who until the 14th century were restricted to religious institutions, and their works rarely caused wider controversy. In response to the printing press and the heresies it allowed to spread, the Roman Catholic Church moved to impose censorship. Printing allowed multiple exact copies of a work, leading to a more rapid and widespread circulation of ideas and information. See print culture, the origins of copyright law. In most European countries lie in efforts by the Roman Catholic Church and governments to regulate and control the output of printers. In 1501, Pope Alexander VI issued a bull against the unlicensed printing of books, and in 1559, the Index Expurgatorius, or list of prohibited books, was issued for the first time. The Index Expurgatorius is the most famous and long-lasting example of bad books catalogues issued by the Roman Catholic Church, which assumed responsibility to control thoughts and opinions and suppressed views that went against its doctrines. The Index Expurgatorius was administered by the Roman Inquisition, but enforced by local government authorities and went through 300 editions. Amongst others, it banned or censored books written by René Descartes, Giordano Bruno, Galileo Galilei, David Hume, John Locke, Daniel Defoe, Jean-Jacques Rousseau, Voltaire. While governments and church encouraged printing in many ways because it allowed for the dissemination of Bibles and government information, works of dissent and criticism could also circulate rapidly. As a consequence, governments established controls over printers across Europe, requiring them to have official licenses to trade and produce books. The notion that the expression of dissent or subversive views should be tolerated, not censored or punished by law, developed alongside the rise of printing and the press. Areopagitica, published in 1644, was Milton's response to the Parliament of England's reintroduction of government licensing of printers, hence publishers. Church authorities had previously ensured that Milton's essay on the right to divorce was refused a license for publication. In Areopagitica, published without a license, Milton made an impassioned plea for freedom of expression and toleration of falsehood, stating, "Give me the liberty to know, to utter, and to argue freely, according to conscience, above all liberties." Milton's defense of freedom of expression was grounded in a Protestant worldview, and he thought that the English people had the mission to work out the truth of the Reformation, which would lead to the enlightenment of all people. But Milton also articulated the main strands of future discussions about freedom of expression by defining the scope of freedom of expression and of harmful speech. Milton argued against the principle of pre-censorship and in favor of tolerance for a wide range of views. As the menace of printing spread, governments established centralized control mechanisms. The French crown repressed printing, and the printer Etienne Dolet was burned at the stake in 1546. In 1557, the British Crown thought to stem the flow of seditious and heretical books by chartering the stationers' companies. The right to print was limited to the members of that guild, and 30 years later the Star Chamber was chartered to curtail the great enormities and abuses of diverse contentious and disorderly persons professing the art of mystery, of printing or selling of books. The right to print was restricted to 2 universities and to the 21 existing printers in the City of London, which had 53 printing presses. As the British Crown took control of type founding in 1637, printers fled to the Netherlands. Confrontation with authority made printers radical and rebellious, with 800 authors, printers, and book dealers being incarcerated in the Bastille in Paris before it was stormed in 1789. A succession of English thinkers was at the forefront of early discussion on a right to freedom of expression, among them John Milton, 1674, and John Locke, 1632-1704. Locke and the Pursuit of Happiness. However, Locke's ideas involved primarily around the concept of the right to seek salvation for one's soul, and was thus primarily concerned with theological matters. Locke did not support universal toleration and freedom of speech. Some groups, like atheists, should not be allowed according to his ideas. By the second half of the 17th century, philosophers on the European continent, like Baruch Spinoza and Pierre Bayle, developed ideas encompassing a more universal aspect, freedom of speech and toleration, than the early English philosophers. By the 18th century, the idea of freedom of speech was being discussed by thinkers all over the Western world, especially by French philosophers like Denis Diderot, Baron d'Holbach, Claude Adrien Helvetius. The idea began to be incorporated in political theory, both in theory as well as practice. The first state edict in history proclaiming complete freedom of speech was the one issued December 4, 1770 in Denmark, Norway, during the regency of Johann Friedrich Struensee. However, Struensee himself imposed some minor limitations to this edict in October 7, 1771, and it was even further limited after the fall of Struensee with legislation introduced in 1773, although censorship was not reintroduced. John Stuart Mill, 1806-1873, argued that without human freedom, there can be no progress in science, law, or politics, which according to Mill required free discussion of opinion. Mill's On Liberty, published in 1859, became a classic defense of the right to freedom of expression. Mill argued that truth drives out falsity, therefore the free expression of ideas, true or false, should not be feared. Truth is not stable or fixed, but evolves with time. Mill argued that much of what we once considered true has turned out false. Therefore, views should not be prohibited for their apparent falsity. Mill also argued that free discussion is necessary to prevent the deep slumber of a decided opinion. Discussion would drive to onwards march of truth, and by considering false views, the basis of true views could be reaffirmed. Furthermore, Mill argued that an opinion only carries intrinsic value to the owner of that opinion. Thus, silencing the expression of that opinion is an injustice to a basic human right. For Mill, the only instance in which speech can be justifiably suppressed is in order to prevent harm from a clear and direct threat. Neither economic or moral implications nor the speaker's own well-being would justify suppression of speech. In Evelyn Beatrice Hall's biography of Voltaire, she coined the following phrase to illustrate Voltaire's beliefs: "I disapprove of what you say, but I will defend to the death your right to say it." Hall's quote is frequently cited to describe the principle of freedom of speech. In the 20th century, Noam Chomsky states that if you believe in freedom of speech, you believe in freedom of speech for views you don't like. Stalin and Hitler, for example, were dictators in favor of freedom of speech for views they liked only. If you are in favor of freedom of speech, that means you are in favor of freedom of speech precisely for views of despise. Professor Lee Bollinger argues that the free speech principle involves a special act of carving out one area of social interaction for extraordinary self-restraint, the purpose of which is to develop and demonstrate the social capacity to control feelings evoked by a host of social encounters. Bollinger argues that tolerance is a desirable value, if not essential. However, critics argue that society should be concerned by those who directly deny or advocate, for example, genocide. See limitations below. Democracy. The notion of freedom of expression is intimately linked to political debate and the concept of democracy. The norms of limiting freedom of expression mean that public debate may not be completely suppressed even in times of emergency. One of the most notable proponents of the link between freedom of speech and democracy is Alexander Macleay John. He argues that the concept of democracy is that of self-government by the people. For such a system to work, an informed electorate is necessary. In order to be appropriately knowledgeable, there must be no constraints on the free flow of information and ideas. According to Macleay John, democracy will not be true to its essential ideal if those in power are able to manipulate the electorate by withholding information and uh, stifling criticism. Macleay John acknowledges that the desire to manipulate opinion can stem from the motive of seeking to benefit society. However, he argues choosing manipulations negates in its means the democratic ideal. Eric Berendt has called this defense of free speech on the grounds of democracy probably the most attractive and certainly the most fashionable free speech theory in modern Western democracies. Thomas Emerson expanded on his defense when he argued that freedom of speech helps to provide a balance between stability and change. Stability, stability and change. Freedom of speech acts as a safety valve to let off steam when people might otherwise be bent on revolution. He argues that the principle of open discussion is a method of achieving a more adaptable and at the same time more stable community, of maintaining the precarious balance between healthy cleavage and necessary consensus. Emerson furthermore maintains that opposition serves a vital social function in offsetting or ameliorating the normal process of bureaucratic decay. Research undertaken by the Worldwide Governance Indicators Project at the World Bank indicates that freedom of speech and the process of accountability that follows it have a significant impact in the quality of governance of a country. Voice and accountability within a country defined as the extent to which a country's citizens are able to participate in selecting their government, as well as freedom of expression, freedom of association, and free media, is one of the 6 dimensions of governance that the worldwide governance indicators measure for more than 200 countries. Social interaction and community. Richard Moon has developed the argument that the value of freedom of speech and freedom of expression lies with social interactions. Moon writes that by communicating, an individual forms relationships and associations with others, family, friends, co-workers, church congregation, and countrymen. By entering into discussion with others, an individual participates in the development of knowledge and in the direction of the community. Limitations. According to the Freedom Forum organization, legal system and society at large recognize limits on the freedom of speech, particularly when freedom of speech conflicts with other values or rights. Limitations to freedom of speech may follow the harm principle or the offense principle. For example, in the case of pornography or hate speech, limitations to freedom of speech may occur through legal sanction or social disapprobation or both. Is on Liberty, 1859, John Stuart Mill argued that there ought to exist the fullest liberty of professing and discussing as a matter of ethical conviction any doctrine, however immoral it may be considered. Mill argues that the fullest liberty of expression is required to push arguments to their logical limits rather than the limits of social embarrassment. However, Mill also introduced what is known as the harm principle in placing the following limitation on free expression. The only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. In 1985, Joe Feinberg introduced what is known as the offense principle, arguing that Mill's harm principle does not provide sufficient protection against the wrongful behaviors of others. Feinberg wrote, "It is always a good reason in support of a proposed criminal prohibition that it would probably be an effective way of preventing serious offense, as opposed to injury or harm to persons other than the actor, and that it is probably a necessary means to that end." Hence, Feinberg argues that the harm principle sets the bar too high and that some forms of expression can be legitimately prohibited by law because they are very offensive, but as offending someone is less serious than harming someone. The penalties imposed should be higher for causing harm. In contrast, Mill does not support legal penalties unless they are based on the harm principle, because the degree to which people may take offense varies or may be the result of unjustified prejudice. Feinberg suggests that a number of factors need to be taken into account when applying the offense principle, including the extent, duration, and social value of the speech, the ease with which it can be avoided, the motives of the speaker, the number of people offended, the intensity of the offense, and the general interest of the community at large. The Internet and Information Society. John Glaville, editor of the Index of Censorship, states that the Internet has been a revolution for censorship as much as for free speech. International, national, and regional standards recognize that freedom of speech as one form of freedom of expression applies to any medium, including the Internet. The Communications Decency Act, CDA, of 1996 was the first major attempt by the United States Congress to regulate pornographic material on the Internet. In 1997, in the landmark cyber law case of Reno v. ACLU, the United States Supreme Court partially overturned the law. Judge Stuart Ray Delzo, one of the three federal judges who in June 1996 declared parts of the CDA unconstitutional, in his opinion, stated the following: "The Internet is a far more speech-enhancing medium than print, the Village Green or the mails, because it would necessarily affect the Internet itself. The CDA would necessarily reduce the speech available for adults on the medium. This is a constitutionally intolerable result. Some of the dialogue on the Internet surely tests the limits of conventional discourse. Speech on the Internet can be unfiltered, unpolished, and unconventional, even emotionally charged, sexually explicit and vulgar. In a word, indecent in many communities. But we should expect such speech to occur in a medium in which citizens from all walks of life have a voice. We should also protect the autonomy that such a medium confers to ordinary people as well as media magnates. My analysis does not deprive the government of all means of protecting children from the dangers of Internet communication. The government can continue to protect children from pornography on the Internet through vigorous enforcement of existing laws criminalizing obscenity and child pornography. As we learned at the hearing, there is also a compelling need for public education about the benefits and dangers of this new medium, and the government can fill that role as well. In my view, our action today should not only mean that government's permissible supervision of Internet contents stops at the traditional line of unprotected speech. The absence of governmental regulation of Internet content has unquestionably produced a kind of chaos. But as one of the plaintiff's experts, but it with such resonance at the hearing. What achieved success was the very chaos that the internet is. The strength of the internet is chaos. Just as the strength of the internet is chaos, so that the strength of our liberty depends upon the chaos and cacophony of the unfettered speech the First Amendment protects. The World Summit on the Information Society, WSIS, Declaration of Principles adopted in 2003 makes specific reference to the importance of the right of freedom of expression for the information society in stating, we reaffirm as an essential foundation of the information society and as outlined in Article 19 of the Universal Declaration of Human Rights, that everyone has the right to freedom of opinion and expression, that this right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Communication is a fundamental social process as basic human need and the foundation of all social organization. It is central to the information society. Everyone, everywhere, should have the opportunity to participate, and no one should be excluded from the benefits of the information society offers. According to Bernd Hugelholtz and Lucy Gibault, the public domain is under pressure from the commodification of information, as item of information that previously had little or no economic value have acquired independent economic value in the information age, such as factual data, personal data, genetic information, and pure ideas. The commodification of information is taking place through intellectual property law, contract law, as well as broadcasting and telecommunications law. Freedom of information. Freedom of information is an extension of freedom of speech, where the medium of expression is the internet. Freedom of information may also refer to the right of privacy in the context of the internet and information technology. As with the right to freedom of expression, the right to privacy is a recognized human right, and Freedom of Information acts as an extension to this right. Freedom of information may also concern censorship in an information technology context, the ability to access web content without censorship or restrictions. Freedom of information is also explicitly protected by acts such as the Freedom of Information and Protection of Privacy Act on Ontario in Canada. Internet censorship. The concept of freedom of information has emerged in response to state-sponsored censorship, monitoring, and surveillance of the Internet. Internet censorship includes the control of suppression of the publishing or accessing of information on the Internet. The Global Internet Freedom Consortium claims to remove blocks to the free flow of information for what they term closed societies. According to the Reporters Without Borders, RWB, Internet Enemy lists the following states engage in pervasive Internet censorship: China, Cuba, Iran, Myanmar, Burma, North Korea, Saudi Arabia, Syria, Turkmenistan, Uzbekistan, and Vietnam. A widely publicized example of Internet censorship is the Great Firewall of China, in reference both to its role as a network firewall and to the ancient Great Wall of China. The system blocks content by preventing IP addresses from being routed through and consists of standard firewall and proxy servers at the Internet gateways. The system also selectively engages in DNS poisoning when particular sites are requested. The government does not appear to be systematically examining Internet content as this appears to be technically impractical. Internet censorship is the People's Republic of China. Internet censorship in the People's Republic of China is conducted under a wide variety of laws and administrative regulations. In accordance with these laws, more than 60 Internet regulations have been made by the People's Republic of China, PRC. Government and censorship systems are vigorously implemented by provincial branches of state-owned ISPs, companies and organizations. Najat Vallaud-Belkacem, a French socialist minister of women's rights, proposed that the French government force Twitter to filter out hate speech that is illegal under French law, such as speech that is homophobic. Jason Farago, writing in The Guardian, praised the efforts to restrict bigotry's free expressions. Thank you very much. It is commonly subject to limitations, as with libel, slander, obscenity, sedition, including, for example, inciting ethnic hatred, copyright violation, revelation of information that is classified or otherwise. The right to freedom of expression is recognized as a human right under Article 19 of the Universal Declaration of Human Rights and recognized in international human rights law in the International Covenant on Civil and Political Rights. Article 19 of the ICCPR states that everyone shall have the right to hold opinions without interference, and everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of 1689, granted freedom of speech in Parliament and the Declaration of the Rights of Man and of the Citizen, adopted during the French Revolution in 1789, specifically affirmed freedom of speech as an inalienable right. The Declaration provides for freedom of expression in Article 11, which states that the free communications of ideas and opinions is one of the most precious of the rights of man. Every citizen may accordingly speak, write, and print with freedom, but shall be responsible for such abuses of this freedom as shall be defined by law. Article 19 of the Universal Declaration of Human Rights, adopted in 1948, states that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to art or through any other media of his choice. Article 19 goes on to say that exercise of these rights carries special duties and responsibilities, and may therefore be subject to certain restrictions when necessary. For respect of the rights or reputation of others, or the protection of national security or public order public, or of public health or morals. Freedom of speech may be legally curtailed in some religious legal systems and in secular jurisdictions where it is found to cause religious offense, such as the British Racial and Religious Hatred Act 2006. The right to freedom of speech and expression. Concepts of freedom of speech can be found in early human rights documents. England's Bill of Rights freedom of speech. For the freedom of speech in specific jurisdictions, see freedom of speech by country. Um, Freedom of speech is the political right to communicate one's opinions and ideas using one's body and property to anyone who is willing to receive them. The term freedom of expression is sometimes used synonymously, but includes any act of seeking, receiving, and imparting information or ideas, regardless of the medium used. In practice, the right to freedom of speech is not absolute in any country, and the right to seek, receive, and impart information and ideas through any media and regardless of frontiers. Today, freedom of speech or the freedom of expression is recognized in international and regional human rights law. The right is enshrined in Article 19 of the International Covenant on Civil and Political Rights, Article 10 of the European Convention on Human Rights, Article 13 of the American Convention of Human Rights, and Article 9 of the African Charter on Human and People's Rights. Based on John Milton's argument, freedom of speech is understood as a multifaceted right that includes not only the right to express or disseminate information and ideas, but three further distinct aspects. First, um, the right to seek information and ideas. Second,